Welcome to Studious. Today, we begin one of the most clinically consequential and exam-critical subjects in medical education, forensic medicine and its relationship with legal procedures. Forensic medicine is not merely an academic subject. It is the real-world bridge between the science of medicine and the administration of justice. Every doctor, at some point in their career, will encounter the legal system, whether issuing a wound certificate, performing an autopsy, or appearing as a witness in court. Understanding the legal framework within which medicine operates is therefore not optional. It is a professional imperative. In countries like India, the medical graduate must be thoroughly conversant with the Indian Penal Code, the Code of Criminal Procedure, and the Indian Evidence Act, as all three intersect directly with medical practice. This series will systematically walk you through every medical legal concept you need, from the foundational definitions all the way to professional negligence and secrecy. Approach this subject not as a legal text, but as a guide to protecting your patients, your practice, and your professional integrity. Let us begin.
Before we dive into legal procedures, we must firmly establish the 4 pillars that make up the medico-legal landscape. The first is forensic medicine itself, defined as the application of medical knowledge for the administration of law and justice. The classic example is the physician who assists investigators in a murder case by interpreting wounds, toxicology, and time of death. The second pillar is medical jurisprudence. This is the reverse relationship, where legal principles and statutes govern how medical personnel must practice. Here, the law dictates medicine. The third pillar is medical ethics, the principles guiding the doctor-patient relationship, rooted in beneficence, non-maleficence, autonomy, and justice. These are largely professional norms rather than statutory requirements, though violations carry serious consequences. The fourth is medical etiquette, the codes of professional conduct between 2 doctors, including consultation norms, referral practices, and collegial respect. A critical conceptual point for your exams, these 4 operate along 2 axes: scope, ranging from interpersonal to system level, and application, ranging from professional conduct all the way to a legal imperative. Mastering this matrix will keep your answers precise and thorough.
The legal system in India, and in most jurisdictions, divides offenses into 2 broad domains, and every medical practitioner must understand this distinction. Civil offenses are disputes between private parties, person versus person. Think monetary disputes, defamation claims, or negligence suits where one individual seeks compensation from another. The state does not prosecute in civil cases. It merely provides the forum. Criminal offenses, by contrast, are framed as state versus the accused. The state becomes the prosecutor because the crime is considered an offense against society, not merely against an individual. Examples include rape and murder. Now, within criminal offenses, there is a vital subclassification based on arrest procedure. Cognizable offenses are serious crimes, rape, murder, dacoity, where police have the authority to arrest without a warrant. However, they must produce the accused before a magistrate within 24 hours to obtain a holding warrant. Non-cognizable offenses are less severe, and police cannot arrest without first filing an FIR and obtaining explicit magistrate permission. This distinction has direct medico-legal implications. It determines how urgently a doctor may need to provide an injury report or appear in a case.
Whenever a death occurs under unexplained or suspicious circumstances, the legal system activates a formal process called an inquest. This is an official inquiry to determine the cause, manner, and circumstances of an unnatural death, and the doctor's role within it is indispensable. The process begins when the cause of death is unknown or suspicious, triggering the arrival of an investigating officer, commonly referred to as the IO. This officer is assisted by panchas, 5 respected head village citizens who serve as independent witnesses throughout the inquiry, lending legitimacy and transparency to the process. The official investigation report drafted at the scene is called the Panchnama. This document captures the scene description, the state of the body, and all relevant physical evidence. If the investigating officer suspects foul play based on the Panchnama findings, the body is requisitioned for a formal medical autopsy. Now, globally, two systems carry the highest legal weight in death investigation: the coroner inquest system and the medical examiner system, both used in Western jurisdictions. These are considered legally superior to standard police or magistrate inquests because they are led by medically or legally qualified individuals with greater investigative independence. In India, the equivalent protections come through judicial oversight.
Not all inquests in India are handled by the police. In certain sensitive categories of death, a magistrate must be directly involved, and it is essential to understand which type of magistrate handles which type of case. The executive magistrate holds an administrative post, typically a district collector or tahsildar. This individual does not practice law, but holds executive powers. The executive magistrate is responsible for inquests in two critical categories. The first is exhumation, the lawful digging up of an already buried body for reinvestigation. This requires explicit magistrate sanction to prevent tampering and maintain evidential integrity. The second is dowry death, defined as the death of a married female within 7 years of marriage under suspicious circumstances or by suicide, which is legally presumed to be connected to dowry-related harassment under Section 304B of the Indian Penal Code. The judicial magistrate, on the other hand, is an actual judge presiding over a magistrate court. The judicial magistrate handles custodial deaths, deaths occurring in police custody, jail, or borstal schools, as well as custodial rape. These are cases involving potential state misconduct, requiring independent judicial oversight. Importantly, a judicial magistrate can also conduct inquests in exhumation and dowry death cases, making them a higher authority in the hierarchy of inquest systems.
Every doctor who enters a courtroom as a witness must understand the hierarchy of courts and the sentencing powers each one holds. This is clinically relevant because it determines the gravity of the case you are involved in and the level of authority you are testifying before. At the base of the pyramid sit the first and second-class magistrates. A first-class magistrate can sentence up to 3 years imprisonment and impose a fine of up to 10,000 rupees. A second-class magistrate is limited to 1 year imprisonment and a 5,000 rupee fine. Moving up, the chief judicial magistrate can sentence up to 7 years with unlimited fines. The assistant sessions judge goes up to 10 years imprisonment with an unlimited fine. The district or sessions judge holds the power to impose any sentence, including capital punishment, though in their case, death sentences must be confirmed by the High Court. The High Court has similar unlimited power and handles capital punishment confirmations. And at the apex, the Supreme Court holds absolute jurisdiction, any sentence, including capital punishment and unlimited fines, without requiring confirmation from any other court. To remember the lower court sentences for your exams, use the mnemonic 10731, corresponding to Assistant Sessions, Chief Judicial Magistrate, First Class, and Second Class, respectively.
When a court requires a doctor to appear and give testimony, it issues a formal legal document called a summons, internationally referred to as a subpoena. Understanding this document is non-negotiable for medical practitioners. There are two types of subpoenas. The first is ad testificandum, from the Latin meaning to testify. This summons calls you strictly to give oral evidence before the court. You are expected to narrate what you observed, examined, or concluded. The second type is ducis tecum, meaning bring with you. Under this summons, you must not only testify, but also produce documentary evidence, such as post-mortem reports, wound certificates, or medical records. Regarding delivery, a summons is legally valid if delivered by police directly, sent by registered post, delivered through an employer, given to a family member at the residence, or even pasted on the door of the recipient's home. This ensures the legal system cannot be avoided simply by being unavailable. If a summons is ignored without lawful excuse, the consequences are serious: a fine or up to 6 months of imprisonment. Regarding conduct money, if you are summoned in a civil case, you are entitled to a travel allowance for your attendance. However, in a criminal case, no conduct money is provided, because assisting the state in criminal justice is considered a mandatory civic duty.
Here is a scenario that frequently appears on medical examinations and can realistically occur in practice. You receive 2 summonses scheduling you to appear in 2 different courts on the exact same date and time. How do you decide which one to attend? The answer follows a clear hierarchical decision tree. The first question to ask, are the 2 courts of different levels within the judicial hierarchy? If yes, the rule is absolute. Attend the higher court. The authority of a superior court always takes precedence. If both courts are at the same hierarchical level, then the second question becomes, are the offense types different? If one case is criminal and the other is civil, the criminal case takes priority. This is because criminal proceedings involve liberty, potential imprisonment, and state-level prosecution, stakes that outweigh civil monetary disputes. But what if both courts are at the same tier and both cases are criminal in nature? In that scenario, the tiebreaker is chronological. You attend the court whose summons you received first. This first received, first attended rule ensures an objective, fair, and legally defensible decision. Whenever you choose one court over another, it is professional best practice to immediately notify the other court in writing, explaining your predicament, to avoid being held in contempt.
When a doctor enters the courtroom, their role as a witness is more nuanced and legally significant than that of an ordinary observer. Understanding the typology of witnesses is essential for any medical practitioner. A common witness relies entirely on first-hand sensory experience. They testify only to what they directly saw, heard, smelled, or physically encountered. They are not permitted to draw inferences or offer opinions. A common witness simply narrates facts. The expert witness, by contrast, is recognized by the court as having specialized scientific or technical knowledge that the average person does not possess. The hallmark privilege of the expert witness is that they are permitted to draw inferences and form professional opinions based on evidence. Classic examples in our field include a ballistic expert analyzing bullet trajectory or a forensic pathologist interpreting post-mortem findings. Importantly, an expert witness can also simultaneously function as a common witness. For instance, a physician who personally witnessed a crime scene can testify to both their observations and their professional conclusions. There are 2 critical legal risk concepts every doctor must know. A hostile witness is one who suddenly reverses their sworn statement, contradicting initial evidence and damaging their own side's case. This is legally significant because leading questions become permissible against them. Perjury is the criminal offense of willfully lying under oath, punishable by imprisonment.
Evidence is the foundation upon which all legal decisions rest, and the Indian Evidence Act provides a comprehensive classification system that every forensic practitioner must internalize. Evidence is broadly divided based on how it is acquired and how it is presented. The first major branch encompasses evidence acquired outside the courtroom. This splits into direct evidence and indirect evidence. Direct evidence means the witness personally experienced the crime. They saw it, heard it, or were otherwise sensorially present. This is the gold standard. Indirect evidence did not arise from personal witnessing. It splits further into 2 subtypes. Circumstantial evidence, where a chain of related facts points to a conclusion. For example, a person purchasing rat poison on the same day as a rat poison death. And hearsay evidence, where the witness heard the accused verbally admit to the crime to someone else. The second major branch covers evidence produced inside the courtroom. This includes oral evidence, spoken testimony delivered from the witness stand, and documentary evidence, which comprises physical records submitted to the court, such as post-mortem reports, injury certificates, ballistic reports, or hospital records. In forensic medicine practice, the expert witness almost always deals with documentary and oral evidence simultaneously. The post-mortem report is documentary. Its oral explanation in court is testimonial. Both must be accurate, consistent, and scientifically defensible.
One of the most emotionally charged and legally significant areas of forensic medicine involves statements made by individuals who believe they are about to die. The law recognizes a profound principle here. A dying person, standing at the threshold of death, is presumed to have no reason to lie. This presumption gives dying statements extraordinary legal weight. However, there are two distinct mechanisms for recording such statements, and confusing them in an exam or in practice can have serious consequences. The dying declaration, practiced in India, is a statement recorded from a dying person and can be taken by anyone present, a doctor, a nurse, or a police officer. Ideally, it should be recorded by a magistrate. No oath is administered, the accused lawyer need not be present, and cross-examination does not occur. Critically, it only achieves full legal value if the patient subsequently dies. If the patient survives, the declaration becomes merely corroborative evidence. The dying deposition, practiced internationally, is far more formal. It can only be recorded by a magistrate. An oath is administered, the accused lawyer must be present, and cross-examination is permitted. Crucially, a dying deposition carries high legal value even if the patient survives, because its procedural rigor is built in from the start. Remember this key distinction. Declaration equals informal Indian practice. Deposition equals formal, requires a magistrate, and is legally valid whether or not death occurs.
When a doctor appears as a witness in a criminal trial, they will pass through a standardized 4-phase examination process. Understanding this sequence is not just academic, it equips you to give your most accurate and legally effective testimony. Phase 1 is the oath. Before any testimony begins, the witness swears or affirms to tell the truth. This is a critical moment because it is the act of taking the oath that activates the legal possibility of perjury charges. By taking the oath, you are legally bound to the truth under penalty of criminal prosecution. Phase 2 is the examination in chief, led by the public prosecutor. This is an open, narrative examination where you are allowed to present your findings, conclusions, and expert opinions in full, comprehensive detail. Questions here are open-ended and designed to elicit your complete clinical and forensic narrative. Phase 3 is cross-examination, conducted by the defense lawyer. This phase is specifically designed to challenge your testimony, testing your methodology, exposing inconsistencies, and attempting to create reasonable doubt. Questions here are often leading and aggressive. Phase 4 is re-examination, led again by the public prosecutor. The purpose here is to rehabilitate any damage done to your testimony during cross-examination, clarifying ambiguities, restoring context, and reestablishing the scientific integrity of your findings. A thorough expert witness knows their report inside out before entering Phase 2.
One specific type of question cuts through the entire trial process with special legal significance: the leading question. A leading question is defined as a closed-form question that is deliberately worded to guide or force the witness toward a specific answer, leaving no room for elaboration or explanation. The classic example is, did he use a gun? The question itself suggests the answer and forecloses nuanced response. Understanding when leading questions are permitted and when they are prohibited is essential for every doctor appearing in court. Leading questions are permitted during cross-examination, which is conducted by the defense lawyer. The defense uses them strategically to pin down or constrain a witness's testimony, limit the damage of expert findings, or expose weaknesses in methodology. Leading questions are prohibited during examination in chief. The purpose of the examination in chief is to allow the witness to give a full, unguided, honest narrative. Allowing leading questions at this stage would compromise the integrity of the testimony. There is one important exception. During re-examination, the public prosecutor is normally prohibited from using leading questions unless the presiding judge has officially declared the witness a hostile witness. In that case, leading questions become permissible precisely because the witness has betrayed their own side and needs to be constrained. This is a highly testable and frequently misunderstood point.
As we conclude the first section of this series, it is important to step back and synthesize the overarching role of the medical professional within the legal system. The doctor's function in forensic and medico-legal contexts can be understood in 3 sequential phases. Phase 1 is objective discovery, the translation of raw medical data into factual truth. This includes the autopsy report, wound assessment, toxicological findings, and inquest documentation. It is the moment where medicine speaks to the law in the language of evidence. Phase 2 is procedural rigor, navigating court hierarchies, responding appropriately to summonses, understanding your role as a common or expert witness, and presenting your evidence through the 4 phases of trial testimony. This phase demands not just scientific expertise, but legal literacy. Phase 3 is the ultimate goal, and this is perhaps the most profound professional principle in forensic medicine. The medical professional does not pick a side. They do not advocate for the prosecution or the defense. They serve as an objective, scientific anchor in proceedings that are otherwise dominated by legal argument, advocacy, and the human tendency toward bias. A physician who misrepresents their findings, even with good intention, can send an innocent person to prison or allow a guilty one to walk free. Medical knowledge, correctly applied within this legal blueprint, ensures that justice is neither blind nor misinformed.
We now enter the second major domain of forensic medicine, the law of consent. Consent is the legal and ethical cornerstone of every medical procedure, and a doctor who operates or examines without valid consent is legally exposed to assault charges under the Indian Penal Code. For consent to be legally valid, 4 pillars must be satisfied. First, age thresholds. For any life-threatening procedure or surgery, the patient must be over 18 years old to provide valid consent independently. For routine, non-invasive physical examinations, the threshold drops to 12 years, a point often tested in exams. Second, linguistic clarity. The explanation and consent process must be conducted in the patient's native language, completely free of medical jargon. Explaining that a patient needs a tracheostomy in English to a patient who only understands Bengali is legally deficient. Third, direct communication. The doctor themselves must communicate directly with the patient. Delegating the consent conversation to a nurse or using a family member as the sole messenger does not constitute valid consent by the physician. And fourth, comprehensive disclosure. Truly informed consent requires the doctor to outline all benefits, risks, expected complications, and the natural course of the disease if left untreated. Critically, if a patient refuses treatment after full disclosure, even refusing a mammogram for a detected breast lump, documenting an informed refusal provides the physician with a critical legal shield against future negligence claims.
Consent in medical practice does not exist in a single form. The law recognizes several distinct types of consent, each with different scopes of validity and legal weight. Implied consent is consent communicated not through words, but through action. When a patient pays a registration fee, collects a token, and sits in a waiting room, they have implicitly consented to a non-invasive consultation. This form of consent is only valid for non-invasive examinations. It does not extend to drawing blood, performing a pervaginal examination, or any procedure that breaches the body. Expressed consent is an explicit agreement, either oral or written. Written consent carries the highest evidentiary value in court and is mandatory for any invasive procedure. If a doctor performs a venipuncture or a pervaginal examination without written expressed consent, they are legally vulnerable to assault charges, regardless of clinical intent. Proxy consent is consent given on behalf of another person who is unable to consent independently, most commonly a parent consenting for a minor under 18. There is an important exception here, the loco parentis exception, which applies when a child is away on a school trip or hostel stay and a parent is unreachable in an emergency. In that scenario, the teacher or warden may legally consent on the parent's behalf. Finally, blanket consent, a single document consenting to any and all procedures, is entirely invalid under Indian law, except in acute life or death emergencies.
Euthanasia represents one of the most ethically and legally fraught areas in all of medicine, and its legal status in India is precisely defined. Understanding the distinction between active and passive euthanasia is critical both for exams and for clinical practice. Active euthanasia is defined as an act of commission, the deliberate taking of a positive action to end a patient's life. The paradigm example is administering a lethal injection. In India, active euthanasia is strictly illegal under all circumstances. Even if a terminally ill patient, fully conscious and competent, voluntarily and repeatedly requests to be mercifully killed, administering that lethal dose constitutes murder under the Indian Penal Code. Voluntary consent does not decriminalize active euthanasia. Passive euthanasia, by contrast, is an act of omission, withdrawing or withholding life-sustaining treatment, such as removing oxygen support or discontinuing intravenous nutrition. In India, passive euthanasia is legal under rigorous constraints. The landmark legal precedent here is the Aruna Shanbhag case, decided by the Supreme Court of India in 2011. This case involved a nurse who had been in a persistent vegetative state for over 3 decades following a brutal assault. The Supreme Court's ruling established that passive euthanasia may be permitted to end prolonged suffering in a persistent vegetative state, provided that consent is obtained from both legal guardians and the treating physician, followed by mandatory approval from a court-appointed medical board.
Professional misconduct in medicine is governed not by courts of law, but by the Medical Council of India and its state counterparts. These bodies are empowered to investigate and punish doctors for unethical conduct that violates the standards of the profession. The 6 primary categories of professional misconduct can be remembered with the hexagon of the 6 A's. First, alcohol, treating patients while under the influence of alcohol or drugs. Second, abortion, performing illegal pregnancy terminations outside the legal framework of the Medical Termination of Pregnancy Act. Third, adultery, engaging in an inappropriate sexual or romantic relationship with a patient. Fourth, advertising, engaging in unethical self-promotion, including misleading advertisements or making exaggerated claims about one's expertise or outcomes. Fifth, association, collaborating with unqualified practitioners, commonly called quacks, for financial commission. Sixth, addiction, substance dependence that impairs professional judgment. Beyond these 6 primary offenses, several secondary misconducts are also recognized: issuing false certificates, demanding bribes, criminal conviction by a court of law, and dichotomy, the practice of making unnecessary patient referrals solely for the purpose of fee splitting with another provider. The punishment pathway follows 2 steps. First, the medical council issues an official warning. If conduct continues or is severe, the ultimate penalty is penal erasure, the permanent removal of the doctor's name from the medical registry, effectively ending their career.
Medical negligence is a chain, and that chain must be complete. Every link must be proven for a negligence claim to succeed. The 4 essential links are known as the 4 Ds of professional negligence, and breaking any single link invalidates the entire claim. The first link is duty. A formal, recognized doctor-patient relationship must have been established. This is crucial. If a patient is turned away for non-payment of a non-emergency consultation fee before any examination occurs, no duty of care has been established. There is no legal relationship, and therefore no claim can be made. The second link is dereliction. Given that a duty existed, the doctor must have failed to apply the standard skill and reasonable care expected of a similarly qualified professional. This may be an act of commission, doing something wrong, or an act of omission, failing to do something necessary. The third link, and the most complex, is direct causation. The dereliction must be the direct, proximate cause of the injury. If a patient ignores medical advice and applies a traditional remedy to a wound, causing infection and limb loss, the patient's own interference breaks the causal chain. The fourth link is damage. There must be tangible, demonstrable physical harm or death resulting directly from the dereliction. Emotional distress or inconvenience alone does not satisfy this element. All 4 links must be present and provable simultaneously.
Not all medical negligence is equal in the eyes of the law. Depending on the severity of harm and the degree of culpability, a negligent doctor may face civil proceedings, criminal prosecution, or both. Understanding the critical distinctions between these 2 tracks is essential for any practicing physician. Civil negligence typically involves less severe outcomes: prolonged pain, unnecessary hospital admission, temporary disability. It is adjudicated by the consumer forum or civil court, framed as patient versus doctor. The standard of proof is the preponderance of evidence, meaning it is more likely than not that negligence occurred. Punishment is monetary fines only, no imprisonment. Importantly, defenses such as contributory negligence and informed refusal are valid and accepted. Criminal negligence involves grave damage, loss of a limb, permanent disability, or death. It is adjudicated by the criminal court, framed as the state via public prosecutor versus the doctor. The standard of proof is essentially absolute. It must be proven beyond reasonable doubt that the damage resulted strictly and exclusively from the doctor's negligence. Punishment includes imprisonment, with or without fines. Crucially, defenses like contributory negligence and informed refusal are completely invalid in criminal proceedings. This is a highly testable distinction. The same defenses that protect you in civil court are inadmissible in criminal court. The threshold of harm and the standard of proof are both dramatically higher on the criminal track.
Medical negligence is rarely black and white. The law provides a sophisticated framework for allocating fault along a spectrum, recognizing that harm can arise from the actions or inactions of multiple parties simultaneously. At one extreme is patient negligence, where the doctor bears 0% of the fault. Consider a scenario where a physician prescribes the correct antibiotic regimen for a wound infection, but the patient ignores the prescription and instead applies traditional cow dung to the wound, resulting in sepsis and limb amputation. The physician prescribed correctly and appropriately. The harm was entirely the patient's own doing. The doctor holds no legal liability whatsoever. In the middle of the spectrum sits contributory negligence, where both the doctor and the patient contributed to the harmful outcome. For instance, a doctor who fails to prescribe antibiotics and a patient who concurrently applies an unhygienic traditional remedy. Both contributed. In civil proceedings, the court weighs the relative degree of fault and splits the monetary penalty proportionally between the parties. At the other extreme is composite negligence, involving two or more physicians who each contributed to the harm through independent failures. A classic example: one doctor misses a knee fracture on imaging, and a second doctor treats the knee injury but fails to identify a concurrent pelvic fracture. The court evaluates each physician's independent dereliction of duty and apportions the shared financial penalty accordingly. Understanding this spectrum is critical for both defense strategy and for exam success.
When a negligence claim is brought against a physician, the central legal question is, did the doctor meet the required standard of care? Two pivotal legal frameworks are used to answer this question, and both are extensively tested in medico-legal examinations. The first is the Bolam test, derived from the 1957 English case Bolam v. Friern Hospital Management Committee. This test defines the standard of care for medical professionals in a way that protects reasonable clinical practice. Under the Bolam test, a doctor is not considered negligent simply because an elite specialist performs a procedure better than a general graduate. The doctor is legally protected if they possessed ordinary, accepted medical skill and expertise and followed the established clinical guidelines of at least one recognized responsible medical body. Crucially, a doctor who follows either the ICMR protocol or the WHO protocol is protected. They do not have to follow every available protocol, just one credible one. Inventing and following an entirely personal, unverified protocol, however, offers no legal protection. The second framework is res ipsa loquitur, Latin for the thing speaks for itself. Also called the doctrine of common knowledge, this doctrine is invoked when the negligence is so blatant that even an uneducated layperson can recognize the fault without any expert testimony. The paradigm example is a surgical sponge or clamp left inside a patient's abdomen after surgery. No expert is needed. The act of leaving a foreign object inside a patient defies all reasonable care.
One of the most important and frequently misunderstood doctrines in medico-legal law is vicarious liability, captured in the Latin maxim respondeat superior, meaning let the master answer. This doctrine establishes that a supervising authority, the master, is legally responsible for the negligent acts of those working under their direct instruction.
In a hospital context, if a medical intern botches a procedure while under the direct supervision of a chief surgeon, it is the chief surgeon, not the intern, who bears the legal negligence. The chief's position of authority and responsibility for oversight makes them the legally accountable party. This principle has enormous implications for hospital administrators, department heads, and senior consultants who oversee trainee doctors. Every order given to a junior is a legal commitment. Now, a particularly nuanced application of this doctrine is the borrowed servant rule. Suppose a nurse is borrowed from Hospital A to assist in a surgery at Hospital B under the exclusive and direct supervision of Surgeon X. During that surgery, the nurse inadvertently leaves a surgical swab inside the patient's abdomen. Who is liable? The answer is Surgeon X, the supervising surgeon at the time of the procedure. Even though the nurse is technically employed by another institution, the exclusive supervisory control exercised by Surgeon X during the procedure transfers the full legal liability to them. This principle is directly tested in examinations and has major practical relevance in modern hospital practice.
When a physician faces a negligence claim, the law provides several legitimate defenses. We will cover them in two groups. The first group involves medical and causal shields, those that demonstrate either the absence of negligence or the breaking of the causal chain. The first defense is medical misadventure, also called maloccurrence. This applies to an unforeseeable, highly improbable adverse event that occurs despite the physician having executed all standard operating procedures flawlessly. If a patient underwent a standard antibiotic test dose that showed no reaction, but then went into sudden and fatal anaphylactic shock following the therapeutic dose, the physician has no legal liability because the outcome could not have been predicted despite best practice. The second defense is novus actus interveniens, Latin for new intervening act. This applies when an entirely independent, unforeseeable event occurs after the physician's act and directly causes the harm, effectively severing the causal chain. The classic example: a physician negligently misdiagnoses a heart attack. The patient collapses later, but dies in a severe ambulance crash on the way to hospital. The ambulance accident is the direct cause of death, not the physician's misdiagnosis, and the physician is legally shielded. The third defense is calculated risk, also called the doctrine of greater good. This applies when a treatment with known severe adverse effects is deliberately chosen because it offers the best chance of saving the patient's life, such as administering life-saving radiotherapy that causes significant burns and hair loss in a cancer patient.
Continuing our defensive toolkit, we now examine procedural legal shields, defenses rooted not in clinical facts, but in legal process and timing. These are critically important for exam preparation and for understanding how the law protects practitioners from perpetual legal vulnerability. The first procedural shield is res indicata, also known as the statute of limitations. Under this doctrine, a patient cannot file a legal complaint for damages arising from a negligent act years after the event. The law mandates that a complaint must be formally filed within 2 years of the negligent act occurring. After this window expires, the claim is permanently barred. This prevents doctors from living under indefinite threat of legal action from events that occurred long in the past. The second shield is res judicata, which provides double jeopardy protection. Once a negligence case has been formally decided by a court or consumer forum, the plaintiff cannot refile the identical case in a different parallel court of the same level, seeking a more favorable outcome. They may only appeal upward through the judicial hierarchy. This prevents forum shopping, the practice of filing the same complaint in multiple courts simultaneously. The third shield is product liability. If a doctor administers a medication, uses a medical device, or employs a piece of equipment correctly and with standard care, but a patient is harmed because the product itself was defective, for example, a needle that snaps inside the patient's arm, the liability shifts entirely to the manufacturer or supplier, completely exonerating the physician.
Professional secrecy, also called privileged communication, is one of the most sacred ethical and legal obligations in medical practice. The principle is absolute. A doctor must never disclose a patient's medical history, diagnosis, or treatment without that patient's explicit consent. This trust mandate is the foundation of the doctor-patient relationship. Patients must feel safe sharing their most intimate health information without fear of exposure, or they will simply not seek care. The consequences of unauthorized disclosure include disciplinary action by the medical council and potential civil liability. However, the law recognizes several specific situations where disclosure is not only permitted, but legally mandatory. These exceptions are called privileged communications. First, direct court orders. A judge or magistrate can compel a physician to disclose patient information. Second, notifiable diseases. Conditions such as cholera, tuberculosis, and more recently COVID-19 must be reported to state health authorities, overriding individual patient privacy in the interest of public health. Third, societal protection. If a patient's condition poses a direct risk to third parties, disclosure may be justified. A classic example is reporting a colorblind commercial vehicle driver whose license was obtained fraudulently. Fourth, insurance and government fitness evaluations. Fifth, self-defense in a medical negligence lawsuit, where a physician may reveal relevant records to defend themselves. There is also the concept of therapeutic privilege, a rare and carefully constrained exception where a physician withholds a grave diagnosis from the patient directly and informs relatives instead, applicable only when the patient exhibits suicidal ideation or demonstrably lacks the mental capacity to process the prognosis.
We close this comprehensive session with the most important conceptual distinction in the entire subject of medical law: the fundamental difference between ethical misconduct and legal negligence. These two domains are frequently confused by students and even by practitioners, and that confusion can have serious real-world consequences. Ethical misconduct, the 6 A's, represents acts that are morally or professionally wrong, even if not strictly illegal in the criminal sense. Crucially, ethical misconduct does not require patient damage or a formal duty of care to be punishable. A doctor who advertises falsely has committed ethical misconduct regardless of whether any patient was harmed. Ethical misconduct is adjudicated by the medical council, not by a court of law, and is punished through official warnings or penal erasure, permanent removal from the medical registry. Legal negligence, the 4 Ds, is fundamentally different. It is defined as the absence of reasonable medical skill and care, and it absolutely requires all 4 elements to be proven: duty, dereliction, direct causation, and physical damage. Legal negligence is adjudicated by courts of law, either civil or criminal, and is punished through monetary fines and/or imprisonment. As we close, remember that being a physician in the modern world means operating at the intersection of science, ethics, and law. Mastering this intersection protects your patients, preserves your practice, and ensures that medicine continues to serve the cause of justice. If you found this video valuable, please like, comment, and share it with your fellow students, and subscribe to Studious for more high-yield content like this.